Historically, New York State has provided special protections for people who are involved in the construction trade. Our labor law has two specific sections that are very important to us as attorneys and individuals who work in construction. The first is labor law, section 240, subsection 1. And essentially what that means and what that statute says is that if you fall from a height while working in construction, or if you are hit by an object that falls from a height, then the owner of the property and or a general contractor or some other companies that may be involved in control of the area are absolutely responsible for the injury sustained by the construction worker. In addition, we have Labor Law 241 subsection 6. Labor Law 241 subsection 6 relies upon the regulations in New York State to determine whether an owner or a general contractor is responsible. Essentially, in those cases, what we do is we take a look at how the individual was injured if it wasn't from a height. And we look to see if they were injured as a result of a violation of a New York State regulation protecting workers. If that is the case, then the worker again can be compensated and will be compensated for their injuries. What we often do in those cases is that we hire experts in the construction trade to come in and take a look at the scenario in which the individual was injured to determine whether they're injured as a result of a violation of one of the codes, one of the regulations. And at that point, compensation for our clients is then essentially mandated by our system.